my ear and said, "This must be surreal for Barrett Prettyman."
It was surreal. I might tell you a little bit about the the film. The film was done by George Stevens, the son of the great movie director. And he asked me to become involved because Sidney Poitier and Burt Lancaster were playing Thurgood Marshall and John W. Davis, and they weren't sure what to do, how to stand, how to pontificate, what to hold on to, what to look at, and so forth. So I was asked to come down to Florida, where they built a courtroom to teach these two how to argue before the court. And it was funny, that night George and I had lunch with, had dinner with Burt Lancaster and his new wife. And George said, introduced him, "This is Barrett Prettyman," and Burt said, "Oh, no, I've met him downstairs." And George said, "No, this is the real Barrett Prettyman." But that was a lot of fun, being involved in that movie.
Obviously, your boss, and as well as you, are portrayed there. Give us a walkthrough as to how much was Hollywood and how much was fact, from your perspective.
Well, I told George the things that were sort of out of whack, and he pled, you know, he had to make it interesting, and he had to make it move and so forth. So it's not way off track, but it is somewhat. What happened was, I was in the hospital room with Justice Jackson when the Chief Justice arrived. The Chief Justice made it clear that he had come to talk about something very important. So I excused myself, went down the hall, waited until he left. He left a draft of the opinion with the Justice, who had read it. And he didn't comment on it at all. He gave it to me and asked me to go read it. So I went down the hall again and read it and came back. And he said, "What do you think?" And I said, "Well, it hasn't got very much law in it, but I think really it's really effective. I mean, in the sense that anybody can understand it, really. And it doesn't do some of the things that you're worried about." And he agreed, and he said, "I have some thoughts about changes we can suggest." And as I remembered, I went to see the Chief Justice thereafter and suggested several things, one or two of which he adopted, but others of which he rejected because they would have applied outside the field of education. And he wanted to make it very clear, for quasi-political reasons, that the opinion only related to education. Now, of course, the later history, they would cite it every time that they struck down segregation anywhere, but for the moment, he wanted to curtail some of the criticism by not making it appear that this was some broad-range attack on segregation everywhere.
You certainly were very much aware of Jackson's draft concurring opinion. You talked about it last time you were here, which, by the way, your speech is being aired all week this week on Time Warner. And at the same time, you had the reply memo. At what point did you get a sense that Jackson had sort of abandoned his interest in the concept of a concurring opinion?
Right then, in the hospital. Because the sequence was that he had given me the draft, I had given him my response, and within a matter of weeks, I hope not because of my response, he had a heart attack and he was in the hospital. So we didn't really talk. He didn't talk to me about my memo to him during that short period in between. And so when he read the Warren opinion and realized that even though there were parts of it that he wouldn't, stands that he wouldn't have taken, parts that he might not even agree with, that overall it accomplished the purpose that he wanted to accomplish, and did it without placing blame on on people, which was one of the things he was concerned about. And so I think right there in the hospital is when he gave up all thought of a concurring opinion. I think he also realized that there was a much better chance that there would not be a lot of dissents and concurring opinions as he had originally thought. I mean, his premise, I think, in the beginning was that virtually everybody was going to write. And so he was putting down what he would write if he was going to write. And he was also, I think, trying to see if he could make sense out of going along. In other words, if he was going to strike down Plessy, what would be his grounds for doing so? So when Warren comes along with an opinion that is easily understandable and is not complicated, does not lay fault on anybody, Jackson, my guess is, he didn't tell me this, but my guess is that at that moment he gave up any thought of a concurring opinion, because he told Warren that he liked the opinion, and when I went back to Warren with a few suggested changes, it was with the understanding that Jackson was going to go along.
During the time frame he's in the hospital, and it was for, how many weeks was he in the hospital?
I've got it here, but I don't remember offhand.
March 30 to May 17.
Okay.
7 weeks.
During that period of time, were there other justices who came and visited and were maybe politicking?
I don't know the answer to that because I wasn't there when they came. I don't know. My guess is that not many of them did, simply because they didn't, you know, he had a heart attack, he was still there, and he was under doctor's orders to stay there. And my guess is that they wouldn't have taken a chance on either upsetting him or wearing him out or whatever. So I don't know the answer to that.
I think I've only seen one reference. Frankfurter may have visited him.
Yeah.
Were you in constant contact with him while he was in the hospital?
No. I think I visited him again, and I think we may have talked once or twice on the phone, but I was not in regular contact for the same reason. He was supposed to be forgetting business and getting rested.
Did you get a sense that the timing of the delivery of the decision was pretty much timed to Jackson's appearance? For example, the Saturday conference where they discussed the decision and that they were going to announce it on Monday, did they know that Jackson was going to show up on Monday?
You know, I don't know the answer to that. I don't know how he made it clear that he would be there, because I know it was a surprise to a number of people in the courthouse, and I don't know whether it was a surprise to the other justices or not. My guess is that it was not a surprise to the Chief Justice. We might ask Earl Pollock that when he gets here.
Because it seems surely it's so dramatic as even the scene unfolds here on the movie. You knew he was coming Monday.
Yes.
Yeah, you knew that. Were you one of the few folks who Earl Warren said, "Hey boys, time to come in"?
No, Jackson had sent word, and you know, through a secretary for one thing, she was going to tell me, make sure that I was going to be there. We'd worked pretty closely, and it isn't the kind of thing he would have kept from me.
Right. Though it seems like some of the law clerks, your fellow colleagues, really were not brought in to the level of which you were brought in the case.
We heard that I mean, I didn't check each one out or anything, but we heard that several were not there because they hadn't been told it was coming down.
What's the reaction of the audience when Earl Warren's reading this, and even the opinions had not been, the decision had not been passed out ahead of time, and then he gets to that point where you saw in the film unanimously, which was not written in, but sort of added by him.
Yeah. Well, I remember quite distinctly that when he used this word, there was an intake of breath in the courtroom, because that is the one thing nobody had anticipated. I see that in Earl Warren's own memoirs of the occasion, he says that there was a visible reaction in the audience, and that's what I saw and heard too. I did not see, however, Thurgood Marshall in the audience, and I don't know whether that's because of where I was standing and that I couldn't see all of the audience, but I was quite surprised later to read that he had been there, and I think it's interesting as to who told him to be there.
Yeah, because I don't know where I read this, but someplace where he'd apparently showed up at other Mondays expecting it, and of course didn't happen.
Well, in this piece, of course, he takes the train for the occasion, so he gets the call from somebody, and I would assume it would either be Earl Warren or Felix Frankfurter.
Mm-hmm. After the decision is rendered, they retire back to their offices. Were you there with Jackson? Was there any conversation?
Yeah, but Jackson didn't come back to the office for very long. He went home. Mm-hmm. He wasn't supposed to leave the hospital when he did, and I don't know what effect that had on his ultimate demise. But I mean, he was not supposed to be out.
Was he done for the balance of that term?
I am having trouble remembering that because there wasn't that much time between then and when he passed away. But my impression is that he did not go back to the hospital, that he went home and that he spent a lot of time home. But whether he came in or not, I just don't remember.
After the decision's announced and clerks go down, the clerks kind of gather together, must have gathered together at some point. What was the scuttlebutt?
Well, we were all very tuned in to what was happening outside, how this was being received. Unfortunately, we didn't have a C-SPAN or CNN in those days, and it was much more difficult to get word, but people were calling friends in different places trying to see what the reaction was. And we were all very concerned, and rightfully so.
I don't recall whether there was a conscious press effort to indicate to the media that this was just the decision and not the order as to how this decision was going to be implemented, that there was in fact going to be a re-argument. Did that come at the same time?
Yeah. Yeah, and I think that that was all part of the quasi-political decision and presentation, was the fact that they were not immediately saying this has to happen tomorrow. Mm-hmm. And nobody knew how fast it had to happen.
Did Jackson have any reason to talk to you afterwards about the case?
Well, not really, both because he was not there very much, but also he knew that the decree was very important to him. It had bothered him from the beginning. So, okay, we can say that it's the end of segregation, but then what do we do? And what do we tell the judges to do? He was very worried about that. And I think that he was trying not to worry about the case because of his health, but at the same time he was worried about that particular aspect and had been thinking all along about what form the decree should take. But as I say, we weren't able to get together very much. Now, several times I went out to his house to work on opinions, where it's a house where Jack Kennedy subsequently lived, and Ethel and Bobby Kennedy lived, and Ethel still lives, although I understand she's trying to sell it. But I don't think it was during that period between the decision and the time he died. I don't think I went out there because he was sick. I remember him being quite well when I went out there, so I don't think I did.
I'm going to turn off this. You stayed on after Jackson died. You stayed on and worked for John Marshall Harlan.
Well, I worked with Frankfurter first.
Yeah, okay. And you were asked by the Chief Justice to participate in the research for what would turn out to be Brown 2. In doing the research and in being part of the clerk process, did you get any feeling that you were maybe continuing to carry a torch of Justice Jackson as the Brown 2 order was being implemented? Did you feel any burden there at all?
Well, I was doing two things. Number one, for all of the justices, I was part of that pool that was doing research into various things totally outside the record. I mean, it was an interesting process that people have not commented upon very much. But my particular job was to see if I could get together maps of cities that showed where black and white people lived and where their schools were, and what kind of school systems they had, so as to see as a practical matter what we were dealing with in saying, hey, you've got to integrate the schools. The other part that I was doing was I had constant contact with Justice Harlan, who wanted everything he could get his hands on in regard to these cases, and he had asked me for a memo on what I thought the decree should look like. And what I concluded by then was that the school systems were far, far more complex than I had anticipated. I just thought that you went to the school nearest to where you lived and that was the end of it. But there were all kinds of systems in place throughout the country for establishing where people would go to school. And I didn't understand how we could come up with a decree that would cover all of these situations. And but I did write a memo making rather extensive recommendations about what the decree might look like. So those were the two parts that I was working on more or less at the same time.
Would Jackson have been happy the way the order ultimately came out in Brown v. 2?
Well, I think he foresaw a lot of what I found, and that was that it was a far more complex factual situation than the people on the court had assumed, or in effect were assuming when they said, okay, it's unconstitutional. And as you know from his various drafts of his concurring opinion, he was very upset about what they actually ultimately did, and that was to turn it back to the district courts without much guidance as to how they were to proceed. He thought that that was unfair to the district judges. On the other hand, I had mixed emotions about it, because while I agreed with him that that had an element of unfairness in it, I also saw all the complexities of the systems and wondered how in the world, if the court was going to tell them how to do it, what in the world would it say that would meet all of these disparate systems? So I was pretty torn.
After you left your clerkship with Frankfurter and then Harlan, did you continue to follow that particular case and its legacy? Since you were part of it, you're intimately part of the birthing of Brown versus Board, did you then have feel like a stake in it as well? Yes
and no. I followed it carefully in the papers, but I did not in any way try to get behind the public story. I didn't call up clerks and try to find out what was really going on or anything of that sort. I just didn't feel like that was my place. But I did have a great interest in how it was progressing. And I thought several strains that fascinated me. One was the slow conversion from simply getting rid of enforced segregation and moving into integration, which really was not part of the original decision. What the justices, I think, intended was to say you are to strike down enforced segregation wherever it appears, but they were not saying that you had to take steps to affirmatively integrate. But that came about through a very slow process, and I found that absolutely fascinating. And the other thing that I found fascinating and quite sad, of course, was the fact that segregation was not done away with in so many places, and that even today, 50 years later, we have integrated or segregated schools in so many places. And the whole history of how that came about and why, because you hear arguments that that really is a choice of many black people, that they would rather have their children in black schools rather than integrated. On the other hand, you see all kinds of things that are done in places to really enforce segregation again, or still. So that whole trend has fascinated me too. But only as an active observer, I mean, not as anyone who really knows anything other than what you read.
You were intimates with the Kennedys, and the Kennedys went through that certainly very tumultuous civil rights time. Was there a period of time where, because of your relationship, that you either were asked or kind of offered your thoughts on perhaps the best way to attack what was going on, whether it be Mississippi, whether it be
Well, I was not actively involved in the civil rights, as, for example, Burt Marshall was. I did attend a number of meetings. I did go to Mississippi and Alabama with Bob. I was in on some of the meetings. I was there the day that he discovered for the first time that there were virtually no blacks on his staff at the Justice Department. And so I was on the periphery, really. I was not actively involved. I did some things on the edge, such as creating a huge playground in the middle of Washington, in the black section of Washington. That was Bobby's idea, and that the president wanted to push, and things like that. But I was not intimately involved in that aspect. I was supposed to be both Jackie's and the president's representative on the Interagency Committee for Transport Merges. I was supposed to be the transportation expert, which of course was absurd.
John, I got a lot of things, my head's swimming. Do you want to jump in with any particular questions, John? While he's thinking, I'm going to, for just a second. Jackson dies October 9th, 1954. Did you get a sense regarding his health? I mean, in the sense of here's May, he comes out of the hospital, goes to the Supreme Court, he goes home. Did you get a sense that things were imminent?
No. No, I thought he was in improving health.
Yeah. And you came up here, by the way, to the funeral, didn't you? Or was
yes.
You here? Do you have any recollections of the funeral here in Jamestown?
I had a recollection of how beautiful it was up here. And what a nice, quiet section of the country was for him to have grown up here and really be a small country lawyer and then end up the way he had. I think it's really quite remarkable, and particularly in light of his lack of education. I mean, it's a wonderful story. I'm absolutely amazed that it hasn't been told more than it has.
Well, I guess that's our challenge.
Yeah.
Was May 17th the end of the term? Did the court recess?
I don't think so. I think it still had some, I think it still sat for another few weeks.
Okay. And do you remember Jackson being present or absent? I think you're right. I think there is an additional...
Yeah, and I don't think he was.
Okay.
but I could be wrong about that.
I want to look at the journal of the court.
Yeah, I'd be interested in that myself.
I've never seen anybody really document that.
No, I'd be interested in that too.
A couple of disparate questions. One is, Nicholas Katzenbach, did your paths cross with his while in the, he was in the Kennedy administration?
Yeah, he was in the Justice Department, yeah.
He was the assistant AG. Did Bobby Kennedy sort of set him aside as saying, you're going to be the head man here in the sense of dealing with the civil rights issues, you're going to be the spokesman?
Well, I think he looked principally to Burke.
Marshall.
For the civil rights. He was not only head of that division, but I think he was the one that Bobby really turned to. But Nick was involved in all of those crises. I mean, he's a very smart guy.
Fabulous picture of he and Wallace together.
Yeah.
That's the best. You were so active in the District of Columbia and continue to be so. One of our claims to fame here in Jamestown, New York, was the first elected mayor of Washington, D.C., Walter Washington.
Really? Yeah.
And I was wondering if you, had any recollections or reflections on Walter Washington?
Well, I didn't know him intimately. I certainly knew him just from being an active part of Washington, and you go to things, and the mayor is there all the time. And I used to see him and his wife quite regularly, but I mean, we would talk casually. I don't mean that we were great friends or anything, but I would see him all the time.
He ended up being sort of the senior statesman as time went on there?
Yeah, yeah.
Even in our neck of the woods, he's, we have this Lucille Ball, and we have Roger Tory Peterson, Robert Jackson, and then there's Walter Washington, who's...
Mm-hmm. I hadn't realized that he came from here.
Yeah, he graduated from high school here, and
interesting.
It's a whole fascinating story.
Yeah. See, my father was corporation counsel at one time, and I guess that would have been before Walter Washington, though, wouldn't it? Because they had the city was really run by, not a city council, but I forget the names that they had, but there's a group of... Commission or something. But he knew all of them, and then I think Washington came in after that.
I think I forget the full story, but he was one of the first appointed mayor, and then was the first elected mayor in Jamestown. And I never really had a chance to interview him, kind of like what we're doing here.
Mm-hmm.
He was very gracious on the phone, and always, next time.
Very nice guy. Yeah, very nice guy.
Have you had a chance to sit down with the gentleman who will be with us tomorrow at any point? Has there been any other gatherings like this?
No. I saw Frank Sander, I think, once years ago when we had some kind of Frankfurter function. But I don't think I've seen Earl Pollock since clerking days. If I have, I don't remember it. And John Fassett, I don't think I've seen him either since those days. We haven't been in contact at all.
Among the law clerks during that term, were you particularly close to any of them? Not particularly well acquainted?
Well, we only had 18 of us in those days, and I was an only clerk until I got to Frankfurt and Harlan, and we all knew each other very well. Yeah, oh yeah, because we had lunch all together quite often. Yeah, and we would visit each other's chambers from time to time. I mean, it was much more kind of collegial than I think it probably is today, or since then, as a matter of fact, when they doubled the number of clerks particularly. And then
in that 1953 term, were the clerks really of one mind about the Brown case? Or was there debate among the clerks?
Well, I'll be interested in seeing what these fellows say. My impression was that Earl and Frank were certainly of like mind, but I'm not sure about John. I don't remember whether he reflected the reticence of his justice or not. He says in his article that his co-clerk was the reticent one and that he wasn't. So I'll be interested to see what he says about that. I hope somebody asks him.
Well, maybe you can, or I might. In your conversations with your clerk colleagues, at the earlier points, did you reflect the reticence of your boss, or did you speak more from your own perspective?
Well, you have to understand that I didn't see this reticence that we're talking about in Jackson. Jackson's reticence was not about the result.
Right.
It was about how you got there.
The argument. Right.
And what argument you gave for getting there, what was the legal basis of it, and what kind of decree were you going to fashion? I mean, those are the kinds of, and what do you do about D.C., where you don't even have equal protection? And since Jackson, in his unpublished concurring opinion, was coming down so hard on equal protection, what was he going to say about D.C.? I mean, those were the kinds of things that were a problem for him, but not in terms of what the ultimate result should be. At least if he had that concern, I didn't see it.
In the period before the heart attack, did you have conversations with Jackson, or he simply drafted the concurrence, showed it to you, and you wrote the memo as a response?
Well, you know, I would love to be able to tell you exactly what happened, and I can't. You understand, as an only clerk, I'm writing 15,000 memos a year, drafting a few opinions, and all the rest of it. So I don't remember all these conversations. My guess is that we did talk about it occasionally, but I do not recall that he told me about his draft until he gave it to me. But you know, that was those were the two sides of Robert Jackson. The side that was so outgoing and so friendly and so funny, and just a wonderful companion, along with a guy who closed everybody out too. I mean, you know from my article about him as Solicitor General that he didn't tell anybody when he was Solicitor General, even people on his staff, what he was going to argue or you know, a lot of things that he was doing. He just kept it inside.
In that 1 week before his death in October 1954, the court begins its term and has a short ceremonial proceeding, and then is in the long conference for the rest of that week. The one immediate implementation of Brown was really the implementation of bowling, because the D.C. schools, including the one just down the block, were desegregated that fall, and there was rioting and trouble just down East Capitol at the high school. Do you remember that? Was that a...
I sort of do, yeah. I mean, when I say I sort of do, I remember that they were among the first to do away with segregation. And I remember that there was a reaction, but I don't remember, like I do some of the other riots or things like that, I don't remember that vividly about what happened.
Casey?
The only question I have, and I kind of got this sense reading some of the work that you've written, as well as the last time you guys were here and talked about this case, I believe, at the Chautauqua Institution. It's been said, and correct me if I'm wrong, Jackson had some Justice Jackson had some misgivings about the whole process at first. Can you explain to me what he went through during this case, and if he had that sense that maybe he was a little uncomfortable with the idea of the laws of the country maybe getting ahead of what the general feeling of the public was regarding this case?
He was someone who believed very strongly in the rule of law, and that you didn't do things by overt dictum. You didn't just direct people to do things without giving a sensible reason grounded in the law. And he was having trouble from the beginning, particularly when Vincent was alive, in hearing the articulation of any theory that made a whole lot of sense to him, other than the fact that he knew within himself that the time had come, probably long since come, for segregation solely on the basis of race to be struck down. I mean, he knew that. But what he was wrestling with was, how do we say this? How do we even come to grips with it ourselves in making it sound as if it is in fact grounded in the law rather than just a change of heart on the part of 9 men. He was also concerned, I think from discussions at the conferences or perhaps with individual justices, that the court was going to be looking for a scapegoat here and saying that people had misperceived or people had done the wrong thing or they hadn't paid attention to the law and so forth. And he knew, being the good lawyer that he was, that they hadn't misperceived anything. They'd done exactly what the Supreme Court had told them that they could do. Segregate on the basis of race so long as the facilities are sufficiently equal. And he was also concerned, as you know from his concurring opinion, about simply turning all of this back to poor district judges living down there with their neighbors in the deep South who could even be in harm's way and who could not say, I'm merely doing what the Supreme Court told me to do when the Supreme Court was not telling them to do anything except use your good judgment. Those were the kinds of things that were giving him pause. And as I said in my speech when I was here last, I think one of the great feelings he had when he read Earl Warren's opinion was relief that Earl Warren, A, was not doing some of the things he was afraid of. Certainly was not faulting, for example, anybody. And secondly, that while it was not grounded in the premises that Jackson had been prepared to adopt, it did make enough sense. It was something that even the man in the street could understand, that if you take children and separate them forcibly solely because of their race, that you are saying that the races are unequal, and guess who is inferior? And in that day and age, 1954, you couldn't do that any longer. You shouldn't have been doing it before, but you certainly couldn't do it then.
Do you think he had a sense of what was to come in the 60s?
I'm sorry?
Do you think he had a sense of what was to come? I mean, he died in 54, but do you think he had a sense of what was coming in the 60s? Some of what the country was wrestling with as far as the civil rights movement?
I think he would have had a pretty good guess that it was going to be about as difficult as it has been. That it would be successful in some places, be done very quickly, harmoniously. In other places, it would be done, but it would be difficult and create a lot of hard feelings. And then in a third set of places, it wouldn't be done at all. He was so practical. He was a very practical man. He was not a dreamer. Although, as you know from his language, he had a wonderful way of expressing things in a way that appealed to people. But I mean, he was not a social scientist. He thought first, what is actually going to happen here? What is best for everybody? What should happen? And so forth. So my guess is that he would not have been surprised.
Jim, Bob, anything, a burning question that you...
Should be mine for tomorrow.
Bob, do you have anything that...
I'm curious, you've talked a little bit about how, for example, that the clerks were more collegial than they would be today. How would you compare today's Supreme Court with the Supreme Court of Justice Jackson?
Well, I've thought a lot about that, and in some respects, it's very much the same, in the sense that a lot of people ask questions, and a few hardly ask any at all, if at all. And when I compare the intelligence and integrity, you have the gamut, if you will. So in that sense, it's the same. But on the other hand, they ask more questions today. In those days, you had most of the questions coming from Frankfurter. You had a lot from Jackson. A little later, you had a lot from Stewart, and then and so forth. But today, except for Thomas, you get questions from virtually everybody. Very few arguments that everybody doesn't ask at least one question except Thomas. And sometimes even he asks a question. So there are more questions today. You can argue that a court that had Clark, Vinson, Minton, and Burton on it was a weak court because they were not giants. On the other hand, look at the others that you had on there who were quite remarkable justices. And today, I certainly wouldn't name anybody who is not remarkable, because I still hope to argue my 20th case there. But it varies even today as between the very, very bright and the people who are merely very bright. Another difference is that the cases were a lot different in those days. You had a lot of cases involving navigable waters and people who slipped on the dock and all that kind of. I'm trying to think of the name of the statute that they had so much trouble with, but they had cases that they would never look at today. The nature of what they look at today has changed very dramatically. But the way the court operates is really essentially the same. I understand the conferences are different, that Chief Justice Rehnquist likes short conferences and doesn't like people to drone on and keeps them pretty clipped. Whereas under his predecessors, and particularly in 1954, several of the justices were intent on speaking their mind no matter how long it took.
Terrific. This is just terrific. This is a bonus.